What crime did I commit?
Pardon?
What crime did I commit?
Allege that you committed the crime.
I didn't commit that crime.
If you want to interrupt me, I'll answer your question. But if you want to keep interrupting me, I'm not going to play that way. I'll answer your question. Court calls case People versus Dwight Miller.
Ashley Lonnie for the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Miller, who approaches your. Mr. Miller, can you please state your name for the record?
Dwight Miller?
Thank you.
And Your Honor, my belief is that my client does want to set this for preliminary examination. However, I am uncertain. He and I have had some conversations, and frankly, I believe he wants to make some statements to the court. I advise him against it, but at this point, I think he wants to talk.
So, we're understanding this is a criminal matter, right?
It is.
Okay, so basically, man, it stemmed from a falsality. All this whole thing, I was falsely arrested, something I never did. I got a sworn affidavit.
Sir, I'm sure your counsel has advised you. I'm going to advise you to not say anything else about the subject matter of the case.
Okay.
If you'd like it set for preliminary examination.
I want to challenge jurisdiction.
You want to challenge jurisdiction?
Yes.
Of whom?
Y'all have a jurisdiction of a case that doesn't exist against me.
On what grounds?
What crime did I commit?
Pardon?
What crime did I commit?
Allege that you committed the crime.
I didn't commit that crime.
If you want to interrupt me, I'll answer your question. But if you want to keep interrupting me, I'm not going to play that way. I'll answer your question. You're accused of the crime of attempted or not attempted, but resisting and obstructing a police officer.
So we all aware that this never transpired, right?
I am not aware of that.
Okay.
Is that all you have to say?
Mm-hmm. Yes, sir.
So, Your Honor, I would ask Mr. Miller. Mr. Miller, I'm not submitting frivolous motions.
Can I get my affidavit put in on the record, please?
Affidavit.
My affidavit of the incident that transpired.
Your affidavit of what?
The facts in the case. My statement of what happened. Can I get it on the record?
There will be an opportunity if you so choose, if this goes to a further proceeding, for you to put whatever evidence you want into the court. But this is not the time to do that.
Really? So when is the time to put the evidence in there?
If you want it set for preliminary examination, you'll have that opportunity. And if it proceeds to trial, you'll also have that opportunity.
So once again, I'll ask, do you want to set this for preliminary examination, Mr. Miller?
Sure.
Thank you.
Not really.
See, do you want to set it for prelim or do you want an adjournment?
Preliminary examination.
Thank you.
To your knowledge, all discoveries.
To my knowledge, yes, Your Honor.
People have their witnesses available the 24th.
Yes.
We can try for that date, Your Honor. If possible, I might ask to go one. No, let's do that date. Thank you.
Preliminary examination in person will be set June 24th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Thank you.
You want to speak at this camera? They will have evidence. I will make sure
This courtroom moment starts with a simple but powerful question. What crime did I commit? The defendant appears confused and frustrated, repeating the same question again and again, trying to understand why he's even there. But in court, things don't work the way most people expect. There's a process, and timing is everything. As the hearing continues, the judge stays calm and composed, reminding the defendant not to interrupt and not to speak about the details of the case at this stage. Even though the defendant believes he's been falsely accused, The judge makes it clear that this is not the time to argue facts or present evidence. Then comes the key moment. The judge finally states the charge, resisting and obstructing a police officer. Still, the defendant insists that the situation never happened the way it's being described. What makes this moment interesting is the clear contrast. On one side, you have someone emotional and trying to defend himself immediately. On the other, a judge focused strictly on procedure and order. It's a reminder that in court, even if you feel strongly about your side, there's a right time and place to speak. By the end of the hearing, the case is scheduled for a preliminary examination, where evidence and arguments can actually be presented. Until then, the courtroom stays focused on one thing: process over emotion.